Federal power, university autonomy, and the post-affirmation action order. The Trump administration lawsuit against Harvard. Introduction 1. A conflict beyond administration. The lawsuit filed by the United States Department of Justice against Harvard University is formally about data production in a civil rights investigation. Substantively, however, it is about power, institutional autonomy, and constitutional interpretation, and the boundaries of a federal leverage. At the surface, the dispute concerns whether Harvard failed to comply with document requests related to admission practices following the 2023 ruling of the Supreme Court of the United States of America that race-conscious admissions programs are unconstitutional. Beneath that surface lies a broader structural struggle: how far the execution branch can go in completing compliance from an elite private institutions that depend heavily on federal research funding. This conflict doesn't exist in isolation. It follows a sequence of escalating confrontations between Harvard and the administration of Donald J. Trump, including funding freezes, litigation over federal grants, threats to revoke tax exempt status, and the theoretical and the rhetorical attacks centered on alleged vogue governance. The current lawsuit represents a new front in that confrontation, one that weaponizes legal rights compliance mechanisms to test institutional resistance. Point number 2. The legal background: the end of race-conscious admissions. In 2023, the Supreme Court fundamentally altered the administrations and admissions landscape by ruling that race-conscious college admissions policies violated the Equal Protection Clause. The court concluded that the use of race as a factor in admissions, even under the previously accepted holistic review framework, could not survive constitutional scrutiny. These rules invalidated decades of jurisprudence that had permitted limited consideration of race to achieve diversity. Universities, including Harvard, were forced to restructure admission procedures to eliminate formal racial consideration. However, the ruling left ambiguity regarding direct or proxy-based considerations. Could personal essay referencing racial identity be evaluated? Could socioeconomic indicators serve as substitutes? Could institutional priorities indirectly preserve the demographic outcomes? The Department of Justice investigation emerges from this ambiguity. It, its purpose is not merely to confirm formal compliance but to determine whether race is being considered through indirect mechanisms. The demand for individualized applicant-level data, correspondence, and internal communications reflect a desire to examine the decision-making architecture itself. Point number 3. The government's position: compliance as obligation. The DOJ alleges that Harvard unlawfully withheld data necessary to assess compliance with federal city rights law. It claims that Harvard slow-walked production and failed to provide sufficient material for review. The government does not, in its lawsuit, accuse Harvard of discriminatory conduct. Instead, it asserts that Harvard breached its legal obligation by failing to provide requested documentation under Title VI of Civil Rights Act. Title VI prohibits discrimination on the basis of race in programs receiving federal financial assistance. Universities that receive federal research funding are subjected to these provisions. Compliance investigations are standard administrative tools. The DOJ's argument is procedural. Federal funding entails federal oversight. The oversight requires transparency, withholding data, obstruction, lawful review. Importantly, the lawsuit doesn't seek damages or immediate revocation of funding. It requires injunctive relief, a court order compelling document production. This framing positions the administration as enforcing process rather than punishing outcomes. Yet the context complicates this narrative. The administration previously froze approximately $2 billion in research grants to Harvard, triggering litigation that resulted in judicial restoration of the funds. The current lawsuit therefore appears less like a routine compliance enforcement and more like a continuation of a broader pressure campaign. Harvard's response: autonomy and constitutional boundaries. Harvard maintains that it has acted on good faith and has restructured admissions to comply with the 2023 ruling. It asserts that admission staff do not have access to applicants' race data during the review, and that alumni interviewers are instructed not to consider race. More critically, Harvard frames the dispute one as of constitutional rights and institutional independence. The university contends that government demands may constitute unlawful overreach, particularly if they are politically motivated to extend beyond statutory authority. The university's prior lawsuit against funding freezes was grounded in the First Amendment concern, arguing that the government cannot dictate academic content, admission decisions, or research directions at a condition of funding. This argument draws from the unconstitutional conditions doctrine. The government cannot condition the receipt of federal funds on the surrender of constitutional rights. If document demands are viewed as reasonable compliance checks, Harvard must comply. If they're viewed as tools of political coercion and constitutional calculus shifts. Point number 5. Federal funding as leverage. The structural core of this conflict is federal funding. Harvard, despite its massive endowment, receives billions in federal research grants annually. Federal money flows through agencies that are bound by statutory non-discrimination requirements. That financial dependence creates leverage. Execution power over funding allows administration to initiate investigations, impose compliance audits, freeze distributions, and threaten revocation. Even absent formal funding of wrongdoing, the process itself imposes cost, legal fees, and reputational risks. Administrative burden as well. Other Ivy League institutions reportedly negotiated agreements with the administration to preserve funding. That fact underscores the strategic dimensions. Institutions must weigh resistance against financial risk. Harvard's resistance signals a willingness to litigate rather than settle. From a power analysis perspective, the government strategy exploits asymmetry. Universities rely on federal guns. The federal government does not rely on any single university. Litigation thus becomes a tool not only to enforce but of signaling, political context, cultural war, and institutional authority. The dispute is inseparable from the broader ideological battles over diversity, equity, and inclusion. The administration frames elite universities as bastions of progressive ideology that require coercion. Harvard symbolizes institutional prestige, intellectual authority, and cultural influence. Controlling Harvard reduces symbolic impact. Trump's public threats to seek $1 billion in damage, revoke tax-exempt status, and assert control over patients derived from federally funded research expand the conflict beyond admissions compliance. These threats signals willingness to redefine the relationship between private universities and federal authority. This aligns with broader executive strategy, challenge institutional autonomy in media, academia, and regulatory bodies. The lawsuit fits within that pattern as a procedural escalation rather than an isolation or an isolated legal action. Constitutional dimensions. Three constitutional principles intersect in this conflict. First, equal protection. The 2023 Supreme Court ruling redefined the permission scope of race considered in admissions. Spending. Second, spending clause authority. Congress may attach conditions to federal funding, providing those conditions are clear and related to program's purposes. Third, First Amendment and academic freedom universities possesses certain protection against government's interference in a curricular and academic decisions. The judiciary will likely evaluate whether DOJ's document requests are narrowly tailored to legitimate enforcement goals or constitute overboard intrusion. Courts historically defer to agencies in compliance investigations, but overt political animus could influence judicial scrutiny. Implications for higher education. The outcome of this litigation can reverberate beyond Harvard. Universities nationwide must recalibrate admission systems in a post-affirmative action environment. If courts compel expansive disclosure of admissions data, institutions may face recurring federal audits. Moreover, the litigation signals that compliance is not merely about policy revisions, but about documentation transparency. Internal communications about diversity initiatives may become discoverable. That possibility could alter institutional governance culture. Risk extends to Research funding stability. If administrations of either party use funding leverage aggressively, universities may diversify funding sources or insulate admissions process from federal oversight through structural reforms. The strategic balance. At its core, this dispute is a context over narrative and authority. The administration frames itself as an enforcing civil rights law against opaque elite institutions. Harvard frames itself as a defending constitutional independence against political overreach. Each side must consider second-order effects. If the government prevails decisively, it establishes precedent for deeper executive intrusion into private university governance. If Harvard prevails decisively, it limits federal leverage and reinforces academic authority. Third-order effects involve public perception. Elite institutions already face scrutiny over access, privilege, and ideological biases. Government confrontation may shape public trust either in federal enforcement or in academic governance. Conclusion. Beyond documents. Though formally limited to government production, the lawsuit represents a structural confrontation between federal authority and the institutional independence in a transformed constitutional landscape. The Supreme Court's 2020 decision removed a long-standing admission framework but did not resolve the mechanism in which compliance can be monitored. The Department of Justice's action attempts to operate and operationalize enforcement, as well as Harvard's resistance attempts to define limits. The court will determine whether this episode becomes a narrow procedural ruling or a foundational precedent in redefining the balance between federal power and the elite private universities in the United States of America.